Act 1036. Part 2. Section 13. Management of stool or skin, or family land. 13. 1. Pursuant to Clause 8 of Article 36 of the Constitution, stool or skin, or family land shall be managed in accordance with this part. 2. A chief, tenana, clan head, family head or any other authority in charge of the management of stool or skin, or clan or family land, is a fiduciary charged with the obligation to discharge the management function for the benefit of the stool or skin, or clan or family concerned and is accountable as a fiduciary. 3. A chief, tenana, clan head, family head or any other authority in charge of the management of stool or skin, or clan, or family or group land shall be transparent, open, fair and impartial in making decisions affecting the specified land. 4. A fiduciary under this section who contravenes subsection 2, commits an offense and is liable on summary conviction to a fine of not less than 5,000 penalty units and not more than 10,000 penalty units or a term of imprisonment of not less than 5 years and not more than 10 years or to both. 5. The provisions of the Head of Family Accountability Act, 1985, PNDCL 114, apply to this Act with the necessary modifications. 6. Despite subsection 5, a person shall not bring an action under Section 2 of the Head of Family Accountability Act, 1985, PNDCL 114, against the occupant of a stool or skin, or against the tenana, unless that person a. has first exhausted the established customary procedure for making the occupant of the stool or the skin or the tenana to render account or maintain records of the stool, skin or clan lands, where a procedure exists. B. Is qualified under the relevant customary law to bring an action against the occupant, or C. Is a subject of the stool or skin or a member of a clan of which the chief or tenana or clan head is the administrator of the stool or skin land and has been granted leave by a court upon proof that the person qualified to institute an action failed to take action within 30 days after being informed of the need to take action. Section 19. Areas reserved for common use. 19. 1. A community may set aside or recognize one or more areas of land within the community for common use by the members of that community. 2. The boundaries of any area of land which has been recognized or set aside for common use shall be marked out in the manner determined by the community, including any manner that is customary among the persons who will use that land, to enable those persons to recognize and keep to those boundaries. 3. An area of land recognized or set aside for common use shall be a. Used and managed in accordance with customary law and usage, and b. Consistent with the terms of a management plan and the overall local planning arrangement. 4. The community shall prepare a management plan which may extend to cover the use and management of more than one area of common land. 5. The community may set up a committee comprising persons with the relevant skills to prepare the plan in pursuance of subsection 4. 6. A person who is not a member of the community may, with the agreement of the community, use common land in accordance with the terms of the customary law and usage and the management plan applicable to that land. 7. The basic rights and duties of the members of a community in respect of a common land include a. The right to make reasonable use of common land, jointly with all other members of the community, in accordance with customary law and usage and the terms of the plan. B. The right to use the resources of the common land in accordance with the management plan and customary law and usage. C. The right to exclude non-members of the community from the common land, other than those non-members who are permitted to enter and use the common land. D. The duty to comply with and assist in the enforcement of the rules set out in the plan and laws relating to environmental protection. E. The duty to bear a reasonable and proportionate share of any expenses or losses arising from the management of the common land or from any natural disaster affecting the common land. F. The duty not to transfer any rights of occupation or use of the resources of the common land to any person for a fee. G. The duty to comply with decisions of the community or any dispute settlement body established by the community or other applicable laws to settle disputes arising from the management of the common land, and H. Other basic rights and duties that may be prescribed by the community or other applicable law. 8. The community may prescribe sanctions for breach of the duties in subsection 7. 9. The community may make proposals regarding the sanctions under subsection 8 to the appropriate district assembly for passage into bylaws. 10. The community shall collaborate with the appropriate district assembly in a. The establishment of common land, and b. Making rules for the use and management of common land. 11. For purposes of this section, land includes water bodies. Section 20. Disposal of stool or skin land. 20. A disposal of land for valuable consideration by a stool or skin, or b. A person who is in possession of stool or skin land by reason of being entitled to the free use of the stool or skin land under customary law, is subject to Article 267 of the Constitution. Section 21. Restrictions regarding disposal of natural resources. 21. An instrument that disposes of stool or skin, or clan or family land, or land owned by a group of persons, a corporate body or an individual does not have the effect of granting a right or title to or an interest in natural resources in, under, or on the land. Section 32. General provisions on transfers. 32. A holder of an interest or right in land may, by an instrument, transfer that interest or right to any person with or without consideration. Section 33. Persons qualified to prepare a conveyance. 33. A conveyance shall only be prepared by a legal practitioner in terms of the Legal Profession Act, 1960, Act 32. Section 34. Contract for transfer. 34. A contract for the transfer of an interest in land is not enforceable if the contract is not a. Evidenced in writing, and b. Signed by 1. The person against whom the contract is to be proved, or 2. A person who is authorized to sign on behalf of that person, or c. Exempt under Section 36. Section 35. Mode of transfer. 35. 1. A transfer of an interest in land other than a transfer specified in Section 36 shall be in writing and signed by a. The person making the transfer or by the agent of that person duly authorized in writing, and b. The person to whom the transfer is made or the agent of that person duly authorized in writing. 2. A transfer of an interest in land made in a manner other than that provided in this section does not confer an interest on the person to whom the transfer is made. Section 36. Transactions exempt from Sections 35 and 36. 36. 1. Sections 34 and 35 do not apply to a transfer or contract for the transfer of an interest in land which takes effect a. By operation of law, b. By operation of the rules of equity relating to the creation or operation of resulting, implied or constructive trust, c. By order of the court, d. By will or upon intestacy, e. By prescription, f. By a lease for a term not exceeding 3 years, whether or not the lessee is given power to extend the term, g. By a license or profit other than a concession required by an enactment to be in writing, or h. By oral grant under customary law. 2. Sections 34 and 35 are subject to the rules equity including the rules relating to unconscionability, fraud, duress and part performance. Section 38. Parties to a conveyance. 38. 1. In every conveyance of an interest in land, the expressions used to denote the parties to the conveyance shall be deemed to include their heirs, successors, personal representatives, and assigns, except insofar as a contrary intention is expressed in the conveyance or appears by necessary implication. 2. The persons expressed to be parties to a conveyance shall, until the contrary is proved, be presumed to be of full age and capacity at the date of the conveyance. 3. In a conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, the spouses shall be deemed to be parties to the conveyance, unless a contrary intention is expressed in the conveyance. 4. Where contrary to subsection 3, a conveyance is made to only one spouse, that spouse shall be presumed to be holding the land or interest in the land in trust for the spouses, unless a contrary intention is expressed in the conveyance. Section 39. Subject matter of conveyance. 39. 1. Any word used in a conveyance indicating the intention of the person making the transfer to create or dispose of an interest in land is sufficient for that purpose. 2. A conveyance passes all interest and rights in the land which the person making the conveyance has power to convey, unless a contrary intention is expressed in the conveyance, or appears by necessary implication. 3. A conveyance shall not be construed to convey any title or right which the person making the transfer does not have the power to convey. 4. A conveyance of a usufructuary interest shall state the interest conveyed as the usufructuary interest and shall not a. Be expressed as a lease, and b. Have a limited term or duration. Section 40. Interest taken by person to whom transfer is made. 40. 1. A conveyance of an interest in land may operate to pass the possession or right of possession, without actual entry, but subject to prior rights to the conveyance. 2. A conveyance of an interest in land to a corporation so by its corporate designation without word of limitation passes to the corporation the whole interest which the person making the transfer had power to convey, unless a contrary intention appears in the conveyance. 3. A conveyance of an interest in land to two or more persons, except a conveyance in trust, creates an interest in common and not in joint tenancy, unless it is expressed in the conveyance that a. The persons to whom the conveyance is made take the interest jointly, or as joint tenants, or b. The conveyance is made to them and the survivor of them, or unless it manifestly appears from the conveyance that it was intended to create an interest in joint tenancy. Section 41. Person not party to a conveyance. 41. A person who is not a party to a conveyance may take an interest in land, or the benefit of a condition, right of entry, covenant or agreement which is the subject of the conveyance. Section 42. Effect of extinction or reversion. 42. Where reversionary interest in respect of a lease is a. Transferred, b. Surrendered, or c. Merged. The incidents and obligations affecting a lessee under the transferred, surrendered or merged reversionary interest remain the same. Section 43. Voidable conveyance. 43. 1. A conveyance of land or an interest in land which is made with intent to defraud is voidable at the instance of a person who is prejudiced by the conveyance. 2. Subsection 1. Does not apply to the law of insolvency, and does not extend to a conveyance of an interest in land where the transferee took the interest in good faith and for valuable consideration. 3. A disposition for no consideration of an interest in land made with intent to defraud a subsequent purchaser is voidable at the instance of that purchaser, except that a conveyance shall not be deemed to have been made with intent to defraud by reason only that a subsequent conveyance for valuable consideration was made. Section 44. Unconscionability. 44. The court may set aside or modify an agreement to convey or a conveyance of an interest in land on the ground of unconscionability where the court is satisfied after considering all the circumstances including a. The bargaining conduct of the parties, b. The relative bargaining positions of the parties, c. The value to each party of the agreement reached, and d. Evidence as to the commercial setting, purpose and effect of the agreement. That the transaction is unconscionable. Section 45. Other grounds for varying or setting aside conveyance. 45. The court may set aside or modify an agreement to convey or a conveyance of an interest in land on grounds which include a. Mistake, b. Fraud, c. Illegality, d. Duress, e. Misrepresentation, and f. Undue influence. Section 46. Conveyance to persons jointly, or to person making transfer. 46. 1. An interest in land may be conveyed by a person to be held jointly by that person with another person in the same manner as the interest may be conveyed by that person to another person. 2. A person may, in one capacity, convey an interest in land to be held in a different capacity by that same person. 3. Two or more persons may convey property vested in them to any one or more of themselves in the same manner that they can convey that property to a third party. 4. Despite subsections 1, 2, and 3, the court may set aside a conveyance in order to prevent the commission or continuance of a breach of a fiduciary duty. Section 47 equals restrictions on transfer of land by spouse. 47, except as provided in subsections 3 and 4 of Section 38, in the absence of a written agreement to the contrary by the spouses in a marriage, a spouse shall not, in respect of land, right or interest in land acquired for valuable consideration during marriage, a. Sell, exchange, transfer, mortgage or lease the land, right or interest in the land. B. Enter into a contract for the sale, exchange, transfer, mortgage or lease of the land, right or interest in the land. C. Give away the land, right or interest in the land inter vivos, or D. Enter into any other transaction in relation to the land, right, or interest in the land without the written consent of the other spouse, which consent shall not be unreasonably withheld. Section 48, Agreement with two or more persons. 48. 1. An agreement with two or more persons jointly to pay money, or to make a conveyance, or to do any other act relating to land, to those persons, or for the benefit of those persons, implies an obligation to pay the money or do the act to, or for, the benefit of the survivors of those persons. 2. Subsection 1 applies only so far as a contrary intention is not expressed in the agreement and has effect subject to the provisions contained in the agreement. 3. Any such agreement, whether express or implied, entered into by a person with one or more other persons, shall be construed and be capable of being enforced in the same manner as if it had been entered into with the other person or persons separately. Section 50. Implied covenants by transferor. 50. 1. In a conveyance for valuable consideration there are implied the covenants of right to convey, quiet enjoyment, freedom from encumbrances and further assurance, in the terms set out in Part 1 of the second schedule. 2. In a conveyance by way of assignment or sublease of leasehold property for valuable consideration, there shall be implied the further covenants relating to validity and past observance of the head lease, in the terms set out in Part 2 of the second schedule. 3. In a conveyance by way of sublease of leasehold property for valuable consideration, there shall be implied the further covenants relating to future observance of the head lease and production of title deeds and delivery of copies, in the terms set out in Part 3 of the second schedule. 4. In a conveyance, there shall be implied a covenant by the person who conveys as trustee or under an order of the court that that person has not encumbered the subject matter of the conveyance, in the terms set out in Part 4 of the second schedule, which covenant shall extend only to that person's own act. 5. The covenants referred to in subsections 1 to 4 are deemed to be made by the person or by each person who conveys, as regards the subject matter or a share of the subject matter expressed to be conveyed, with the person or each of the persons to whom the conveyance is made, or, where the conveyance is made to joint tenants, to the tenants jointly. 6. Where conveyance states that a person is conveying by the direction of another person, for the purposes of this section, the person giving the direction is deemed to be the person who is conveying the subject matter and is required to observe the covenants implied in this section. 7. Except as otherwise provided in subsections 9 to 22, a covenant implied under this section may be varied or extended by the conveyance, and the variation or extension shall operate in the same manner and with the same consequences as if the variation was implied under this section. 8. A variation or extension under subsection 7, which wholly removes the personal liability of the person who bears responsibility under the covenant, is void. 9. Where a lease in respect of bare land is granted by a person who holds an allodial or usufructuary interest in the land and the lessee is an indigene of the area where the land is situated, the lease is subject to automatic renewal where the lessee has developed a. The land for residential purposes, b. A farm of perennial crops on the land, or c. A commercial or industrial property on the land, for the same duration as the original lease when the lease expires. 10. A lessee under subsection 9 shall discharge the established customary duties to the lessor. 11. Unless otherwise expressly provided in the lease, where bare land is leased to a citizen of Ghana who is not an indigene of the area where the land is situated, there shall be an implied term in the lease that the lessee is entitled to a renewal of the lease. 12. A lease of bare public land granted by the Republic to a citizen of Ghana is subject to automatic renewal on terms agreed upon by the parties. 13. Subsection 12 does not apply where a. The lease is in respect of a commercial property, or b. The leased property is required for redevelopment. 14. The renewal in subsections 7, 9, 11, and 12 are subject to the original terms of the lease and any new terms agreed upon by the parties to the lease or their successors, agents or assignees, taking into consideration any improvement of the land by the lessee. 15. Where the parties fail to agree on terms for the renewal of the lease, the dispute may be resolved under the Alternative Dispute Resolution Act, 2010, Act 798. 16. If the parties fail to resolve the dispute under subsection 15, the parties may settle the dispute in court. 17. Subject to subsection 6 of section 10, a lease for a fixed term and granted by a Ghanaian to a non-Ghanaian is not subject to renewal unless the lease expressly provides otherwise. 18. Where a non-Ghanaian exercises an option to renew a lease, the renewal is subject to the T11NS agreed upon by the parties. 19. A conveyance of a usufructuary interest shall not specify any duration of the interest, but the holder of the usufructuary interest is subject to the customs and traditions of the area where the land is situated. 20. A holder of a usufructuary interest under subsection 19 shall not alienate any interest in the land, which is the subject of that interest, to a person who is not entitled to that interest without the written consent of an adequate payment to the allodial owner, which consent shall not be unreasonably withheld. 21. A holder of an allodial title may a. In furtherance of the expansion of a town or settlement, and b. For the purpose of serving the communal interest of the beneficiaries of the allodial interest, take over bare land or farmland which is the subject of a usufructuary interest within the area covered by the allodial title. 22. The holder of an allodial title shall not take over land under subsection 21 without a. Prompt payment of fair and adequate compensation which in any case shall not be less than 40% of the plot of land or the market value of the plot of land being taken over, or b. Providing suitable alternative land, where possible, to the holder of the usufructuary interest in respect of the land. Section 51. Implied covenants by person to whom transfer is made. 51. 1. In a conveyance by way of lease for valuable consideration there are implied the covenants relating to payment of rent, repair to adjoining premises, alterations and additions, injury to walls, assignment and subletting, illegal or immoral user, nuisance or annoyance, and yielding up the premises, in the terms set out in Part 5 of the second schedule. 2. In a conveyance by way of sublease for valuable consideration, there shall be implied the further covenants relating to future observance of the head lease and permission to carry out repair under the head lease, in the terms set out in Part 6 of the second schedule. 3. In a conveyance by way of assignment for valuable consideration of land comprised in a lease, there are implied the covenants relating to payment of rent, future observance of the head lease, and indemnity, in the terms set out in Part 7 of the second schedule. 4. Where rent is apportioned in respect of a land, with the consent of the lessor, the covenants in subsection 3 are implied in the conveyance of that land in the same manner as if the apportioned rent were the original rent reserved, and the lease related solely to that land. 5. The covenants referred to in subsections 1 to 4 are deemed to be made by each person to whom transfer is made, as far as regards the subject matter or share of the subject matter expressed to be conveyed to the transferee, with each transferor, if more than one. 6. A covenant implied under this section may be varied or extended by the conveyance and after being varied or extended, shall operate as far as may be in the same manner and with the same consequences as if the variations or extensions were implied under this section. Section 52. Persons to take benefit of implied covenant. 52. The benefit of a covenant implied under Section 50 or 51 is attached to the interest of the implied covenantee, and are enforceable by a person in whom that interest or a part of that interest is vested. Section 53. Benefit of covenants relating to land. 53. 1. A covenant that relates to an interest in land of the covenantee is deemed to be made with the covenantee and the successors in title of the covenantee and the persons deriving title under the covenantee or the successors in title of the covenantee and are enforceable by the covenantee and the persons deriving title under the covenantee or the successor in title of the covenantee to the same extent as by the covenantee. 2. For the purpose of subsection 1, in connection with covenants restrictive of the user of land, successors in title include the owners and occupiers of the land which the covenant is intended to benefit. 3. The benefit of a covenant relating to an interest in land may be made to run with the land without the use of any technical expression if the covenant is of a nature that enables the benefit to run with the land. 4. For the purposes of this section, a covenant runs with the land when the benefit or burden of the covenant, whether at law or in equity, passes to the successors in title of the covenantee or the covenanter, as the case may be. Section 70. Rules for conveyance. 70. 1. A conveyance may be described, at the commencement or otherwise, as a conveyance, an assignment, a lease, a sublease, a trust instrument, an appointment or otherwise, according to the nature of the transaction intended to be affected. 2. A conveyance shall be expressed in clear terms and in plain language, and in particular the words lease, conveys to, interest, land, or and at may be used in preference to the words demise, grants and conveys unto, estate, piece or parcel of land, all and singular and situate lying and being at respectively. 3. In a conveyance, so far as practicable. A. Months shall be written in words without abbreviation and days and years shall be written in figures. B. The names of the parties to the conveyance shall be written in full without abbreviation followed by the full residential and postal address of the parties or, in the case of a body corporate, the registered office or principal place of business of the body corporate. C. Where any other registered conveyance is recited, the registration number of the conveyance shall be stated, and D. Sums of money shall be written fully in words without abbreviation, followed by the same amount expressed in figures within brackets. 4. A conveyance shall, unless otherwise provided in this Act, be made on durable material. 5. Failure to observe a provision of this section does not invalidate a conveyance or provision of a conveyance. 6. Where a date or sum of money is expressed both in words and in figures, and there is discrepancy between the word and the figures, the words shall prevail over the figures unless a contrary intention appears in the conveyance. Section 81. Registrable interest. 81. 1. The interest in land which are registrable include A. Allodial title. B. Common law freehold. C. Customary law freehold. D. Usufructuary interest. E. Leasehold interest, and F. Customary tenancy. 2. An interest in a condominium, an apartment or a flat shall be registered in accordance with regulations made under this Act. 3. For the purpose of this section, condominium means a single estate unit in a multi-unit development in which a person has both separate ownership and common interest with others. Section 82. Registrable rights. 82. The rights that are registrable in relation to land under this Act are A. Le mortgage. B. An easement. C. A restrictive covenant. D. Profit prondra. E. Power of attorney. F. A contractual license, and G. A user right under a certificate of allocation. Section 83. Qualification for title registration. 83. 1. A person, or stool or skin, or clan or family qualifies to register land in the name of that person, or stool or skin, or clan or family if that person or stool or skin, or clan or family A. Is the allodial owner. B. Holds a common law freehold. C. Holds a customary law freehold. D. Holds a usufructuary interest. E. Holds a leasehold interest, of which more than 3 years are unexpired, or F. Holds a customary tenancy. 2. The land registrar shall register the Republic as A. Proprietor of public lands. B. Trustee of lands held by the state in trust, and C. proprietor of land that by operation of law become the property of the state. 3. Subject to subsections 4 and 5, an interest appertaining to or affecting land may be registered under this Act. 4. Where an interest will, according to the terms of the interest, expire without notice of termination within less than 2 years after the date on which an application for the registration of that interest is made, that interest shall not be registered under this Act although the interest may be renewable on notice. 5. Despite subsection 1, a license in respect of one minerals granted under the Minerals and Mining Act, 2006, Act 703, or timber rights under the Timber Resources Management Act, 1998, Act 547, or any other enactment shall not be registered under this Act. Section 119, Indefeasibility of registration. 119, 1, subject to subsections 2, 3, and 4, and to Section 118, the rights of registered proprietor of a parcel of land whether acquired on first registration or subsequently or by an order of a court are indefeasible and so be held by the proprietor together with the rights and privileges attaching to the parcel of land free from all other interests and claims. 2. The rights of a proprietor are subject to the interest or other encumbrances and conditions shown in the land register. 3. This section does not relieve a proprietor from a duty or an obligation to which the proprietor is otherwise subject as a trustee. 4. The registration of a person as the proprietor of land or a holder of an interest in land does not confer on that person a right to minerals in the natural state in, under or upon, the land. Section 120. Interests conferred by registration. 120. The registration of a person as a proprietor of an interest in land. A. Vests in that person the interest described in the acquisition or transaction by which the interest was created, together with the implied and express rights and privileges attaching or appertaining to that land and subject to the implied and express covenants, liabilities, and any other incidents, and B. Shall not cause the benefit or burden of any rights, privileges, or covenants to pass to a transferee of 1. The land, or 2. An interest in land. If the benefit or burden of the rights, privileges, or covenants would not otherwise pass to the transferee. Section 121. Overriding interest. 121. 1. Unless the contrary is recorded in land register, a land or an interest in land registered under this Act is subject to any of the following overriding interest. A. A right of way, a right of water, profit, or a right customary exercised and enjoyed in relation to the parcel of land which is not a recognized interest in land under customary, but which was subsisting at the time of first registration. B. A customary right in respect of a concession granted under the Concession Act, 1962, Act 124, and the Forest Act, 1927, a CAP 157, which was subsisting at the time of first registration. C. A natural right of water and support. D. A right of compulsory acquisition, resumption, entry, search and user conferred by any other enactment. E. A lease for a term of less than 3 years and not capable of extension to a term of 3 years or more by the exercise of an enforceable option for renewal. F. A right, whether acquired by customary law or otherwise of a person in actual occupation of the land except where an inquiry is made of that person and the right is not disclosed. G. A right acquired or in the course of acquisition by prescription or under the Limitation Act, 1972, NRCD 54. H. A charge for unpaid rates and any other money which without reference to registration under this Act, are expressly declared by any enactment to be a charge upon land. 1. An electricity supply line, a telephone and telegraph line pole, a pipeline, aqueduct, canal, where and dam erect constructed or laid in pursuance or by virtue of a power conferred by an enactment, and J. A license in respect of minerals granted under the Mineral and Mining Act, 2006, Act 703, or a timber right under Timber Resources Management Act, 1998, Act 547. 2. Despite subsection 1, and subject to subsection 4, of Section 83, the Land Registrar may direct the registration of a burden, a right and interest specified in subsection 1. In the manner that the land registrar considers appropriate. Section 123. Entries as actual notice. 123. A person who acquires land or an interest in land shall be deemed to have had notice of every entry in the land register which that person would have discovered had that person conducted a search of the land register or inspected the land register. Section 124. Priority of registered interest. 124. 1. Rights derived from instruments recorded in the land register shall have priority according to the order in which the instruments were presented to the registry irrespective of the dates of the instruments and despite the fact that an entry in the land register may have been delayed. 2. Subsection 1 does not apply where there is fraud, notice or mistake. 3. An instrument that is sent by post and addressed to the land registrar in the registration district where the land specified in the instrument is situate and that is received on any day during the hours of business shall be deemed to have been presented at the time the instrument was received. Section 268. Vesting of stool or skin, or clan or family land. 268. 1. On the coming into force of the 1992 Constitution, it is unlawful to vest stool or skin land in the state. 2. After the coming into force of this Act, it shall be unlawful to vest clan or family land in the state.